of an enactment or any act or omission of a person to Supreme Court orders. The Supreme Court can make orders and give the directions to ensure that a declaration of constitutionality is enforced. 3, failure to obey orders. If someone fails to obey an order from the Supreme Court, it is a high crime. If the president or the vice president fails to obey, they can be removed from office. I think this is the area that they were talking about.
So you know something?
She emphasized it.
You know something? We should have tested the law when the president decided to wait for the case in the LGBTQ thing. We should have tested the law in terms of his responsibility in going according to what the law says when a bill comes to him and he decides that it isn't something he's going to sign, and the processes that he needs to do to return it to Parliament and give his reasons. We should have tested the law.
What would have been the right path, basically?
What would have been
the right action by the way of law?
In terms of
test the law.
Yes. In terms of whether the president was right to sidestep his responsibility and indicate that he's waiting for the Supreme Court to judge the case in court. He has a responsibility. The law states that this is the process and procedure you need to follow. Once a bill comes to you and you decide that I'm not in favor of it, it has to go back. The case in court, so far as I can see, is a different issue. It's neither here nor there. You do your responsibility. If it so happens that you do your responsibility and the court finds a different action, then we cross that bridge when we come to it. But I would like to state, the Supreme Court has made their decision. We abide by that decision. Let's move on. The Speaker this morning has said that he is going to open Parliament in the first week of November. He has an assignment, national assignment in Australia to do with courts, and that he will attend but come back early to open Parliament.
So yeah, I got that information as well.
Let's move on. And you see, one of the challenges we have, and I don't know whether it's right or wrong, it's just an observation. We are told the Supreme Court is a master of its own, and they are not bound by previous decisions. Should we look at that again? Because some of the cases are similar, and sometimes they can choose to use previous cases to defend what they want to say. And sometimes they ignore it, because I believe that the Supreme Court should have looked at the Michael Quay situation
from the onset, instead of waiting for it to get...
From the onset.
All right.
So that they could take it out of whatever arguments we are making. That A, B, C, D, E was the reason for this from the way we interpret the law by what Michael Quay did, Honorable Michael Quay did. And we feel it's neither here nor there. And these are the reasons.
Sergeant, I'll come back to you shortly. Let me bring Mr. Timothy into the conversation. You've had the case, you've had the Jantua laying some clarity to some of the issues raised in the court. What is your assessment?
Let me say good morning to Mr. Jantua.
Good morning.
My friend, and to our viewers out there. Jantua has spoken the law. I won't pretend to be a lawyer, but I'm going to use common sense. And then we'll look at the issues. First and foremost, you read an article that talks about the enforcement of the decisions of the Supreme Court. Who enforces decisions of the Supreme Court? Which institution is responsible for the enforcement of the decisions of the Supreme Court, such a way that if you fail to abide by it, then it becomes a problem. Who enforces that is the executive. They have the power to enforce. The Constitution does not enforce its content. Neither does the Supreme Court enforces its decision. The decision is made and then the institution. So it could be said that the president or the vice president, in the disobedience of rulings of the Supreme Court, they can be removed and so on. What is the procedure for that? And we know how it is. I don't need to go there. But you see, I have said it last week, and I want to repeat here. How did we get to where we are? People have mentioned Makoko's ruling, and I still go by that. And I think the Speaker of Parliament, Alban Bagbin, followed the same procedure and then declared the seats vacant. If you read Parliamentary Hazard,
He didn't follow the same procedure.
would you allow me to continue? Should I
Yeah,
continue?
you go ahead.
Uh-huh.
Yeah.
If you read the Parliamentary Hazard on the issue brought against the former MP, it was very clear how the MPP themselves argued. But you see, we are dealing with numbers and majority, and a slip of one of the MPs always causes a problem in Parliament. That is why, if you look at the Makoko's case, in which the former seat was declared vacant, the issue was that the numbers were overwhelming for the MPP side. So there was even no need for someone to pay attention to and to rush to court. Even if they had lost 10 sitting members at the time, or 20, they would have still been in the majority. So in this it was mute as to who should go, even chilling. That wasn't the issue. Here we are with a constitutional interpretation, an issue that was not even before the court, and yet the court sat the full. And that's why people like Senor Hussein and all those people are raising the speed with which the Supreme Court is attending to some selected cases for which they think that is politically motivated sittings and so on. And you see, the lawyers yesterday raised an issue about the fact that one of the Supreme Court judges, Justice Gawu also, is an MPP card-bearing member, and that should recuse himself from the case because when the word go, we feel that his being part of the empanel at that stage was a problem. And the Chief Justice has said, look, how can he use that? Because there have been a former member of Parliament on the Supreme Court, or is it the Appeal Court, and there's one, the PNC Secretary. How can the Chief Justice do that? The Chief Justice's utterances, her body language, her demeanor should be to engender cohesiveness, to engender peace, to engender as a bridge between when there's a stalemate between the executive and members of our parliament and so on. Yesterday, she was questioning how can the parliament not be sitting? The issue before the Speaker, and I like the issue before the Speaker was not about whether parliament was sitting or not. So she quickly saw it and recoiled and so on. And the courts, and for that matter, the judiciary have suffered credibility issues in this country. Their conduct, the way they go about, their demeanor have led a lot of people, including ordinary, to read meaning into whatever they do, which is not good for our democracy. It is not for nothing that Montesquieu and the one who popularized the rule of law, said that there must be separation, not in terms of even personnel, but in terms of functions. And the major thing is to prevent arbitrarness, to prevent that. And that to unnecessarily interfere into the functions of the various institutions, because the Constitution has carved out.
Separation of powers.
Yes, the Constitution has carved out their rules, and where they overlap, you can use compromise, you can even use negotiations, you can sit behind. Where the Supreme Court comes to pronounce issues that are contrary to the functions, or they try to take part of the parliament, but that's where the political question comes in. And you see, this government had a penchant of always invading the premises or the perimeters of institutions that have been insulated by the Constitution, that they should not be partisan and they should operate as it is. You can mention the EC, the Auditor General, and so on, where partisan MPP people have been put there. That's reducing the credibility of these institutions and the personnel that mount there. I think that what the Supreme Court did and what is out there is an indictment on their independence. The Constitution clearly tells how independent the judiciary should be, the conditions under which they should be independent, so that they cannot be manipulated. They should be seen to be carrying out justice without fear or favor or impartially, to the satisfaction of all. Whether you lose the case before them, you can boldly say that, look, I understand, the case went well, I lost it, and so on.
Timothy, let me read some statement from the court yesterday. That is the Speaker's. In a statement to the Supreme Court, the Speaker stated that in terms of orders staying of execution of rulings, the Supreme Court powers under the 1992 Constitutions of the Republic of Ghana and statute to stay execution of ruling are limited to rulings of itself and of courts lower in the judicial hierarchy, but do not extend to a ruling of the Speaker of Parliament, who is not part of the judicial hierarchy.
Yeah. So
that is his call. But
yes.
the ruling
Let
that
me
came,
squash this.
the ruling saying that.
Squash it, but he's still stating that
Yeah,
it does.
let me take you before we take your opinion.
wrong?
So with regards
wrong?
to the first defendant,
How do you continuously say the Speaker is wrong? He's wrong on what
let me
grounds?
lay the foundation for us to get that conversation going. So with regards to the first defendant's rulings in Parliament, a separate arm of government, therefore, such rulings are not rulings
Why do you
within the
describe
judicial
him as an
hierarchy,
arrogant speaker,
so
my
as
brother?
to be the subject
You
matter.
haven't seen the arrogance of
Mr.
Magokwe?
Timothy, I'll come back to you shortly. Please hold on with me. But in a ruling, the Chief Justice explained, given the irreparable harm that could be caused to the constituencies comprising hundreds and thousands of Ghanaians who will be left without MPs and without the possibility of by-elections, as well as the irreversible impact on MPs potentially losing their seats just weeks before the December 7th election, it is necessary for this court to address this dispute promptly rather than issuing a 10-day interim order on Article 97 as interpreted by the law.
You see, interesting. Since when did the Supreme Court realize it? The same Supreme Court sat and have been sitting on the issue of SAL. The people of SAL have been cut off. They've been denied their right to representation for how many years now? Even we are not coming to the conclusion of that matter. They went through the course. They said the Supreme Court told them to come to the High Court. When they got to the High Court, finally ended by saying they have no jurisdiction over this. Reprobate and appropriate. Is that how the Supreme Court should work? Asinov, what happened to the people of Asinov? The same courts. That is why I'm saying that, you see, they give the perception out there that they are too much partisan in their ruling and their activities. And we're not going to run away from that. We will not run away from that. The people of SAL, these people, even if they are losing their representation for how many weeks and for how many days and so on, you are worried about that. You are not worried about people you have denied. Over 32,000 people you have denied. And so on. And for me,
CJ made a defense that this is a constitutional matter, but not a political annihilation possibly.
Which constitutional matter? The issues that they raise there is a representation of the people of the various constituencies. You understand? It is the right of the people, and these matters are heard at the High Court and not at the... Where does the Supreme Court comes into this? Why couldn't the Supreme Court refer them to the appropriate courts? I know, and he knows, that when you send a matter before the Supreme Court and it's not within their jurisdiction, they refer it to an appropriate court, and you go there for the matter to continue.
However, their ruling also overrides any subsequent court.
Their ruling overrides, but it depends on the interpretation of the issues involved. The role of the Supreme Court is purely to interpret the Constitution where there are disagreement as to the reality of the clause. In any case, those who do the enforcement, like those who do the pronouncement, like Bagbin and other people, by their spirit, they interpret what it is before they make the pronouncement and so on. It is when there's a disagreement in that interpretation, it is then sent to the Supreme Court for them to be able to give the accurate interpretation and so on. So for me, I don't think that the matter was even first to go there. The Parliament has its own rule. Parliament is a master of its rules. They go by that. And it's for a purpose. For a purpose that this institution, if we don't set rule to govern them, governance will come to a standstill. Governance will come to a standstill because there's bound to be conflicts. Once there's implementation of policy and its execution, there's bound to be conflict. So the judiciary is there as a watershed to be able to determine what should be done. And you see, justice emanates from the people. And what do you call the rulings of the Supreme Court should take into consideration the mood of the nation. You don't come out with rulings that further exacerbate the already precarious situation of the tensions in government and so on, especially times of elections like this. Your ruling should engender peace and tranquility, should bring harmony and the people together in times of this, so that we continue to know that the Supreme Court is our last bastion. And anytime there's a conflict, that's where we run to. If people begin to look at the rulings of the courts, including the Supreme Court, to be that they do not inure to their benefit, and they're going to take issues into their own hands to interpret the Constitution as the way they want and implement the same. Do you know the chaotic situation we're going to get ourselves into? They should be worried. The Chief Justice and her panel should be worried that there's so much loss of credibility. This is not the first time they are coming to near conflict with members of Parliament and so on. It has been there. Look at the rulings they gave in terms of whether a certain speaker can vote and so on. The conflict.
Okay.
And so on. The fight in Parliament, the e-levies, cases before the Supreme Court, the speed with which they go to handle these cases. When you do that, it is not for nothing that the National Security Minister says they should be careful of their ruling. Let me come.
I'll come back to you briefly. There's more to say. There's something about the Chief Justice on this particular speed issue. I'll come back to you briefly. But let me bring Mr. Isi also into the conversation. So you see, you've heard from Danto, I heard from Mr. Timothy. However, I'm sure you were making some notes from whilst they were speaking. Let's hear from you as well.
Yeah, thank you, Winston. Good morning to you. Good morning to Council. Good morning to Honorable Lawyer. Good morning to our viewers. Good morning to the leader and flag bearer of the New Patriotic Party, Alhaji Dr. Mahmoud Bawumia, the next president of the Republic of Ghana. Inshallah, 7th January 2025, you'll be sworn in. It's a matter of course. We are building a country. My brother cited Montesquieu. Montesquieu's concept of separation of powers is not in abeyance. Its purpose is for, checks and balances. Okay? No authority or wing of government should be too powerful to do what it likes. And so separation of powers is for checks and balances. Parliament checks the executive checks judiciary checks Parliament, judiciary checks the executive. You get it? That is the basis of the concept of separation of powers. So that power will not be absolutely imbued in one wing of the government structure. The Chief Justice yesterday did say that even, and that's where we read Article 2, okay? One lawyer, I told him that the succinct article was Article 2. Even the president of the land and the vice president are subject to the dictates of the Constitution of the Republic of Ghana. So how can a speaker decide to say he's a god unto himself? How? Okay? I have said that the speaker was pushing the agenda of his political party and not the interest of the state. That's why I disagree with anybody who says the comment of the Chief Justice on the matter is wrong.
Of Michael Quay when he also...
I'm coming to Michael Quay. You see, they raised the issue that lawyer said he would have wished this they are spoken about. Michael Quay's issue is not before the Supreme Court now.
But the situation,
no, listen.
But
they cannot be citing issues in Parliament there. Case laws. They are laws, decisions taken by the Supreme Court itself. You get it? Michael Quay's ruling will be properly answered to when the matter proper is gone into. When the ruling is given on Article 97, 1G, when the ruling is given, an answer to Michael Quay's step would have been given to
So are you saying the NDC's inability to take such cases to the court is what has led us where we are?
If you decide you won't take it, that's your matter. If I decide I'll seek interpretation, it's within my right.
Would you also say that the distrust of the justice system is what has led to where we are now?
What?
Distrust.
What distrust? What distrust? The same courts acquitted and discharged the minority leader, and they were excited. Yeah? The judges who started were appointed by this president.
You saw the role of that.
You didn't see that? You didn't see that? Come on. You see, we cannot, as he said, we can't approbate and reprobate. We should be factual to the matters before us. We are building a nation, and we cannot allow anybody to hoodwink the nation and hold the nation to ransom. You have said somebody, and I have said it, my uncle, lawyer John Tua, you know, listen, I have said, nobody in this country will say he doesn't know the reason why these steps are being taken by these members of parliament. It has nothing to do with the 8th parliament. It has nothing to do with the 8th parliament. Okay? It's because our system does concurrent preparation and arrangement towards the next election alongside sittings of the current parliament. Hence, and I have cited here and other places that in the United Kingdom, and we've blended the UK system with the United States. That's what our 1992 Constitution did. That's how can we say majority of our ministers should come from Parliament, right? Right? And that is what, in the British system, that's how it is. Okay? So if you are doing that, but in the British system, they dissolve Parliament before elections are held. And so if you decide to go independent or go to another party, it's your own matter.
But Parliament has not been resolved.
No, I'm saying, no, so it's not been dissolved. Because our system, our parliament sits whilst we are doing our election and these processes. To the point even 12 midnight, you will see members of parliament sitting down and dozing, waiting for midnight to dissolve parliament and then sit for the swearing in and all that. You get it? It's so inconveniencing. So please, let's allow the processes. And the lawyers have something they call mens rea, right? The intentions behind.
And what was the intention?
Okay? What's the intention? You see, cross-carpeting in the British system, there's a way of cross-carpeting. Okay? You go to parliament, you've been voted for, the people's mandate. And you on your own, but before you even cross-carpet, you should consult your people. But some people sometimes do it on their own, willy-nilly. So you do that cross-carpeting.
Did they consult the party before they decided to take that decision?
No, there's a process going. There's elections going on.
Did they consult the party?
They have not, in this parliament, they've not crossed any carpet.
But they've declared their intention.
They've filed.
Yes. And that, you see, the speaker dependent
you
on
made mention of the fact that that particular narrative, the intention behind the law, should advise the direction with which...
The intention is in the existing parliament. That's my understanding of that law.
Okay, that is your understanding.
Yes.
Okay.
The actions by all these people has nothing to do with the 8th parliament.
By your understanding?
Yes. No, that is the fact. Because the speaker, the Honorable Haruna Idrisu and the minority leader took this action because the EC posted the statement of polls. Okay? Because after they had filed for the next parliament. So that is why we need interpretation, succinct interpretation of Article 97(1)(g). And that is what the Supreme Court is going to do.
Your majority leader, Fenyo Markin, stated that these persons have not communicated to the party.
I'm coming to that point.
Yes.
I'm coming to that point.
You know why?
That's why when he said...
Do they have reasons not to? Based on the initial circumstances where similar members of the party were written to be adjudicated from the party subsequently.
Good.
Or excommunicated, if I may say.
The matter between Andrew Siama's 2020 vis-a-vis this, the party engaged Andrew and all those processes were gone through. And when he was adamant and decided he wasn't going to listen to the party and co, the party wrote to the speaker. The speaker didn't just go ahead. The speaker invited Andrew Siama and engaged him. After thorough engagement, he made his ruling. Okay? That's not the case here. This speaker just got the thing and then he decided he was going to kick them out. He never invited a single of them. He didn't. What happened to all the Authorum party by the
they've not complained.
Lawyers and co? No, something.
Listen,
a member of parliament has brought something to your notice that there's a statement of poll, and these 4 individuals are no more on the ticket of their parties. Okay? Look, he himself, I was happy when he was starting his submission, Honorable Timothy. He said he is not a lawyer, but he's going to speak on the basis of common sense. That's what he said. And common sense, indeed, lawyer is here. It's an integral part of the processes of the law. Okay? So please, yesterday I was excited. What happened? The Supreme Court, the Chief Justice cited clauses in the Constitution, articles in the Constitution to make a case.
You know, let me.
On matters of law.
You read very pungent.
So the Michael Quay one,
yes.
You see, it will be answered when the proper ruling is. Some people have disagreed. There was one MP, I've forgotten, at that time. He disagreed with Michael Quay. At that time, lawyer Atachian disagreed with Michael Quay. But the ruling, and nobody, as he said, showed interest, because even if 10 people go, the majority is still majority. But now, you see, the reality now is when it happens, it affects. So people show interest, okay? And then there's a stay of execution. The speaker decides to disrespect that. Because in 1997, let me tell you something, in 1997, okay, a case went to the Supreme Court. When Rawlings won re-election, okay, and then he said all the ministers should stay. And then Kwame Pepra was to present a budget. J.H. Mensah said no. In the case, J.H. Mensah versus the Attorney General. He said no, he's not properly so made a minister, so he cannot.
You know, you said something about checks and balances.
Yes.
You said so much about checks.
Yes.
Where do we find the balance?
Why? You say these are part of the checks and balances.
No, when we have most of the things you said are the checks.
Yes.
We have to keep checking.
Yes.
But where do we put the balance?
The balance is where the Supreme Court has now given a ruling. You must obey. Okay? So it brings a balance. You cannot on your own do what you want because you want to please your party. Okay? Because you are the speaker.
So those all the because you are mentioning, they are all your thoughts, basically.
Why not? That's why you brought me here.
All right. So let me still get your thoughts on this.
Yes.
The speaker said something.
Yes.
The justice, Supreme Court justice, she added that it is vital for the Supreme Court to expedite proceedings, bridging the standard 14-day period.
Yes.
By allowing the constitutional action to proceed through a statement of case, requiring parties to submit their claims within 7 days, and moving quickly to resolve the issues presented. According to the Chief Justice, had all parties complied with these directives within the suggested timeline, the case could have been resolved within the 10 days the application requested.
Good. So that's it's one when matters are brought before, and it's true. Anybody who says the Supreme Court cannot pick and choose is just joking. Some matters hinges on the exigency and cohesion of the states. That's why she said she doesn't understand why Parliament is not sitting.
No,
because on the say so.
You said it here.
You said as a citizen, the Supreme Court.
No, but you said it here.
We are all citizens of this country.
And they have the powers. Okay? Yes, because
Not in the mouth.
and somebody thinks that the
Parliament didn't say they are not
his
sitting.
own party, so he must stop the functioning of Parliament.
Stop saying that
No.
for interest
Oh,
of his
please,
own
my
party.
brother, when you were speaking, I was
You
here.
interjected.
I didn't talk.
You interjected
What is
several
this?
when I was speaking. I
You
had to
come
warn
here
you.
to represent
In all of
Please.
the speakers, gentlemen, please let's take calm. Let's take calm. Please take time.
What's that?
You did the same to me.
I'm coming.
Didn't you see that he
I'll come
was
back
saying
to
to
you.
you?
I do?
I'll give you
I was
time.
sitting
I'll
here.
give you
Did I
time.
Don't you
I'll
let
give
your
you time
arguments.
to
Stop
rebut.
that.
I'll give
You
you
also
time.
stop interjecting when I'm talking.
Both of
But you
you.
also stop that when I'm interjecting.
Your microphones
The number
are
of
your microphones
I
are
don't
off.
interject you.
Don't
Gentlemen.
throw your hands to me like
Okay,
that.
I'm reading something very
You have to be
important.
very careful the way you are throwing
Take
your
it
hands to me,
easy.
please.
Come on.
Sorry, take it easy.
Stop it.
Take it easy. Gentlemen, take it easy.
Yours is more
The justice
despicable
said
than a
something. The
nuisance.
Supreme Court
You
said something.
started it this morning.
What is
Didn't
this?
you start it?
Mr. Timothy,
One day
You started it.
hits them,
it's
then they
okay.
begin to misbehave.
Let's take time. Let's take time.
Stop using
Gentlemen,
such language, please.
All right, I'm reading something from the Supreme
Please
Court.
allow me
It
to
doesn't lie in your mouth to
Mr.
describe what I do.
Mr. Timothy.
Let the host do it.
Let's all stay calm. Stay calm.
You are disrupting my
Mr. AC, take it easy. Your time is up. Your time is up. All right, so Mr. Timothy,
And you came in to disrupt
Mr. Datua, I think, gentlemen, I know you guys.
You thought when you were doing, I like it.
All right, so viewers, we take a short commercial break. When we come back, we're still going to be touching this case issue. And there are certain facts which we'll have to have it addressed right here on the show. So I want you to stay tuned. We're right back after this.
Newsflash is brought to you by Franco Trading Enterprise. Still, fun papa fear.
Welcome back to Newsflash here on the Prime Morning Show. The conversation is getting heated. Nonetheless, we try as much as possible to bring you the discussion and clarity of the issues at hand. Now, let's bring your messages that you've been sending via the WhatsApp numbers. Samani Hamza says, good morning to you and to your guest, more especially to the great lawyer of our time and the most honest politician, Dr. Kwame Jantwa. Even though I am an NDC, but this one of the politicians I love so much. In fact, we are not expecting anything from the Supreme Court except unanimous decision. In fact, the Supreme Court judges should be ashamed of their conduct. When we were cursing and calling those people involved names until current happenings in our days, that we realized those heroes who were involved were 100 percentage points right. All right, that is Hamza sending us that message there. Let me take one from Baba from Damango says, Madam Host, yeah, this is Mr. Host. Why? You called the man a pastor. Tell him to tell the truth just for once. He's disgracing us. Okay, that's Mr. Host. Thank you very much. Baba Damango says, the case was just like football betting. Man City versus Kotoko. Easy to predict. This is from Baba Damango. That's according to the Baba who just spoke right there. Philip from Keta Abochi. Philip says, good morning to everyone. The judges in Ghana are behaving like educated. All right. What happens in the Supreme Court yesterday was barbaric. Ghanaians would not believe in the judiciary system again. Ghanaians are unhappy with Mrs. Tokonu. All this stuff will stop if the next NDC government comes back to power. John Mahama is winning with 57.3%. We have one says, a headmistress style of a CJ here, her demeanor is very offensive. That's interesting there, the same CJ. Now, Aaron Babako Kokomisa from in Accra says, good morning to you. The economy can only grow at a faster pace if there is enough room for a conducive socio-economic environment for entrepreneurs to thrive. By providing access to capital, creating a supportive regulatory environment, investing in infrastructure, and promoting entrepreneurship education, government can foster an environment where entrepreneurs can succeed and drive economic growth. This is Aaron there. Let me take one from Datus from Lulubi. Good morning, Joy Prince. All right, Joy Prime. Never again shall Ghanaians vote for this Akufo-Addo government. The lies and incompetence are too much. Bagbin is the best one for the year. Good morning, Joy Prime. In fact, Bawumia has just missed the opportunity given to him by the incoming president, John Dramani Mahama. Instead of him to answer JM's questions, he went on to set his own questions, of which Ghanaians voted JM out of power. So there is nothing new of Bawumia, and he only said questions which he cannot and even answer himself. Master Rahman inside Tuna, Sola Tuna Kalba. All right, let me take one more. Okay, this is someone wishing special birthday. Okay, I will come back to the birthday wishes very shortly. And Ablade Ifya Kuma Zongo Takrade says, President Akufo-Addo should know that if only Mahama, whose one-term achievement as president is unprecedented, Mahama served one term but still have a better legacy than all those who served two terms, including His Excellency President Akufo-Addo from Ablade, Efia Kumazongo. I'm not surprised Supreme Court dismissed Speaker Gbagbe's objection. Now, it's easier to predict Supreme Court ruling than predicting a football match. So I would suggest Supreme Court rulings should be placed on betting games to make life easy for Ghanaians. For Ablade Efia Kumazongo Despi, who just sent his message. Let me also read one from, okay, this is a long one from vote number 1. Okay, good morning. Okay, this looks like yesterday. It was sent from yesterday. Let me just read one last one from this, from Mowat inside Obuase. It says, Mr. Host, have you read the Class 1 questions Dr. Bawumia asked the visionary, intelligent former President Mahama? What kind of questions are these? Just answer 5 questions about the economy as an economic whiz kid, and you are about the economy as an economic whiz kid, and you are beating about the bush. Hey, Ghana, what kind of leaders ruling our country now? This is from Mawat in Obuase. Okay, someone says, according to St. Augustine's of Hippo, and I quote, an unjust law is no law, unquote. President Kufuor packed the Supreme Court just to overturn a decision of the court against Chikata. Today, he's sitting down quietly in his big house, alone reflecting on how and why he could do that to a fellow human being. Today, it is Nana Addo's turn, twisting the law in his favor. But who do I blame? I blame the NDC who approved Ken Ofori-Atta and co to be ministers. It is too late in the day for the NDC to assert any powers on current situation. Let's leave it. God is in control. Patrick in Accra. Let me take some few more and then we'll come back to the conversation. Jantua, I disagreed with your submission that the Supreme Court has made their decision, so we should abide by it. That is myopic. This Supreme Court is partisan and it lost its credibility several times in cases of national interest, which the Tokono has ignored. Article 117 and 97 and do not need an interpretation. It has never happened in the same parliament and MPP own party constitution. Our Chief Justice is using her personal sentiment, but not the law. Okay, this was, he didn't just disclose his name. Let me take one last comment, then we'll come back to the conversation. Okay, this is, let me read it. It says, let me see how long this goes. K. Frimpong from Konongo says, Doctor, good yesterday. All right, this is a yesterday message. Let me just bring this one to as well. Good morning to your Joy Prime and your able panel. With regards to what is currently happening at the Supreme Court, it's rather unfortunate that but guess what? It's not surprising that some have held their views that the state of our justice system today is even worse than what Galamsey has done to our environment. Coupled with that, Her Ladyship Sophia Akufo mentioned that the Supreme Court today is too predictable, and that's so unfortunate. Abdul Razak from Tamale. Daniel Akpa-Liok from Sandema says, the decision of the court to overturn the decision of the Speaker is a clear travesty of justice and an illegal attempt to use judicial powers to suppress the rights of the Speaker in favor of the MPP. Is it not surprising how the Supreme Court has kept many cases to swiftly react to the desperate Honorable Afenyo Markins, now minority leader in Parliament? Oh. All right, we'll get back to the conversation, but let me read one last one from Alfred Nikote Ashi from Samuel Nasi says, the MPP has nothing to offer we the Ghanaians. If the MPP are saying these MPs' instances are for the future, how can the Article 97A and H apply if those MPs go to election and do not win? The rule shall vacate their seat. If they do not return to Parliament, which seat would they vacate? Or the seat in their rooms? The MPP should give us a break. Greetings to my incoming MP for Odiodio constituency, Honorable Alfred Nikote Ashi. This is from Samuel Nasi. who came to us via your text messages. And thank you for sending all your messages via the WhatsApp line. Keep doing that while the show is going on. We'll read them live before the close of the show. Here with us, Mr. Timothy Awanturim is a former MP for Bosa North Constituency, lawyer Kwame Jantua, senior member for CPP, and George Kojo AEC, Director of Communications, NADMO, a member of MPP Communication Team as well. Let me take some thought from lawyer Kwame Jantua. Lawyer.
Look, let me go into the Constitution. And I must say, I beg to differ with the fact that the Speaker has no jurisdiction to declare a seat vacant. And that is my opinion. When you go to 97, for me, 97 is mandatory. And it says, a member of parliament shall vacate. Let me go to H. Let me ask a question. The current member of parliament who says he's standing for the MPP, H says, if he was elected a member of parliament as an independent, was he? The second deputy speaker, was he the third deputy speaker? Was he elected a member of parliament as an independent? Yes. It goes on to say, an independent and joins a political party. Has he joined the political party? Yes. So how come it's rather in the future? And let me ask, the Adwoa Safo case, where she had been absent from Parliament over 15 days, would the Speaker have had to go to 99, or would the Speaker have had to go to the Supreme Court to find out whether her seat can be made vacant? Wouldn't the Speaker have gone for 97 in his mandatory stance? So what's the difference? That is why I felt, for public interest reasons, the Supreme Court should have taken these precedents in Parliament and broken it down for us to understand. And so far as I can see, it wasn't done. Because even in the introduction of the Speaker, he referred to those cases and laws he had used to come to a decision. And remember, Parliament can interpret, Council of State can interpret, courts can interpret, and the Supreme Court interprets when there is confusion, so far as I understand. When these cases, interpretation from the different seems to be the confusion there, and they come and clear it. I don't see how the Supreme Court would want to stay an action in Parliament. So you stayed the action. Did the Speaker not have his powers? What did he do? He adjourned Parliament indefinitely. Did he not? Is Parliament sitting? I think one of the things that the different arms of government should try and do is to push the positive things in terms of, okay, we want to take decisions, interpret the law so that the different arms can take what we've interpreted and move forward with it. Sometimes, ego plays a part. And I can see ego playing a part within Parliament and the Supreme Court.
But what has happened so far in Parliament?
That comment that was made by the Chief Justice, for me, it exposed her. If she had stopped at the point where Sorry said the speaker has not filed his case and left it there, and not then commented, it would have been fine for me. And the Babintu is also showing, you want to stop my work? Me too. What have I done? I would close Parliament.
Some have also questioned the swiftness of the conclusion of the case. Immediately they rose, sitting, and came back to pronounce a judgment.
We cannot have a lacuna with this particular issue because it's got to do with governance. Equally, the LGBTQI one has public interest. And if the Supreme Court can quickly put a panel together for this, yes, constitutional, because of the public interest element of LGBTQI, they should have done the same. At the current moment, we are 38 days to elections? Will it happen? Because we are all waiting, and it is something that the people are very interested in. And remember, the power of this country lies in the hands of the people. Aren't politicians coming back to the people to ask them for their vote? That shows the power of the people. So, things that have constitutional implications.
Okay, you're in 30 seconds.
Yes, things that have constitutional implications and things that have public interest, I would suggest the Supreme Court takes it up quickly so that there are decisions to it and we move forward.
All right. Thank you very much, Lawyer Kwame Jantuabe. And let me come to former MP Bosa North constituency, Timothy. I want to Timothy.
Yes, you see, this is from Parliamentary Hansard.
Yeah.
I'm just going to paraphrase because it's long. But the Parliament received in November 2020 a petition from the General Secretary for the MPP saying that the Member of Parliament, Andrew Amoako-Esiama, who has been written to, has responded. And they quote the article we're talking about and says that even the MPP constitution says that if you file as an independent, or if you were on their ticket and you file as an independent, it is a forfeiture. Automatically you forfeit it. You see, one speaker, but you see, when it suits them, they go by their own words. But when it does not, they say, oh, this one, there's not about that. If the speaker is a God unto himself and he's seeking to interpret the Constitution, the speaker only announced what he did not interpret any portion. And the speaker knows, he's a citizen lawyer, that he's not properly been clothed to interpret any clause of the Constitution. So it goes on. And you see, when Parliament adjourns Senate, it doesn't mean it as adjourn in perpetuity. That's the term. So there cannot be a lacuna in government. Parliament, by its own standards, knows when to adjourn, and so there's a timetable.
Senate means indefinite.
Yes, but you know there's a process even in law and the procedure by which it can be called back.
Yeah.
It is a phrase that is used to ensure that for now, that is it, but it can be recalled. So senator means that, but it is also, there's a law to be able to cure.
Indicated in his report.
Yeah, to cure that because they cannot sit
the processes have already started.
Yes, to bring. They cannot even adjust senator because even their tenure is 4 years and so on. Look, it is not for nothing that the former Chief Justice, so Akufu said this judiciary is predictable. I didn't say that. Ansar Asare mentioned that. Kwebu mentioned Kwekwaza, mentioned even Professor Abuchi. All of them made comments, insightful comments. And that is what we are basing on. And that was why initially I said that, look, this issue, for we who are not lawyers, it's about common sense. It's about the fact that in Parliament, what is happening to the MPP are afraid. In fact, what they did was a predictive movement to court to stop an intention of the Member of Parliament to move that motion to ensure that the people's seats are vacated, they are no more members of Parliament. Because, I said initially, because of even the numbers involved, and so on. So for me, what the Supreme Court did yesterday, they should have taken the mood of the country into consideration. Justice emanates from the people. Justice is served in the name of the people. At any time, the judiciary, when they are pronouncing judgment, there are some cases that take the form of public interest, like he said. When the public interest overrules that of small interest, the public interest is bigger. And in fact, whether Parliament, the executive, or even the judiciary, they take into consideration when we make this decision or policy, how is it going to affect positively or negatively on the people? I remember that when the people's mind go haywire, we don't have a country. And like he said, I know the speaker. He's not a god unto himself that my brother is. He wants us to know. He's someone who has carried this parliament despite the challenges for the past 4 years. He has presided over budgets. He has presided over the nomination and approval of members of, the MPP executive and so on. He has been leading to ensure that Parliament becomes stronger than he will believe in it, and that Parliament becomes a bastion of our democracy and so on. Where is our parliamentary democracy? Where is our democracy without Parliament, a strong Parliament and so on? So, and I also feel that the judiciary, when they are making pronouncements, they should ensure that people do not read so much partisan meaning into their ruling. They take it or leave it. We know that the Supreme Court has been packed by MPP card-bearing member, which his Lordship Gawu is one of them, a parliamentary candidate of the MPP and so on. We can go to other institutions, go to the Electoral Commission and see the MPP. Even independent state institutions have been choked by MPP appointment. When that happens, it now behoves on you, the one presiding, to conduct your constitutional rule without fear or favor. It doesn't matter whose oath is God. But the fact is that the law must rule, the law must lead us, the Constitution must be our yardstick for the determination of public and even private justice and so on. If we don't do that, I can foresee a situation where tomorrow, if I'm appointed as a card-bearing member of the NDC into any of these independent institutions, you cannot talk, because yesterday you glossed over it and you thought it was nothing because it served your political agenda and expediency.
Right.
For me, what has happened, it should never happen. Parliament has not eroded or gone into the interpretation of the Constitution or any clause at all.
Okay.
What the Speaker did, who is a seasoned lawyer, and there are even lawyers and former Attorney Generals in Parliament who know what he did, was not an interpretation of the Constitution.
All right, thank you very much, Mr. Timothy. Now, let's hear from Mr. George Kojo, AGC, the Director of Communications, a member of MPP Communication team as well.
Thank you.
I didn't know it was called Kojo. I like that name.
Yeah, and my Kwejo, the way they spell it, I've said it many times, but they are still spelling it that way.
How is it spelled?
It's Kwado.
Okay,
They
like
use
that.
DJO. They use
Kwejo.
DJO.
So it's
Yes.
Kwejo?
Yes.
Not Kojo.
KWA.
DWO.
It's Kwejo.
DWO.
Like the
Yes.
Ashanti one.
Yeah. But they use DJO. Anyway, one.
No, it was KWO.
No, the poster that came to me.
On the artwork?
Yes, the artwork.
Yeah.
No, I sent it,
Yeah.
so I think the correction has been.
It's correct. It's been
Because
corrected.
last week it happened.
Yeah, it's been
I
corrected.
sent
It's
it.
been corrected.
Thank you.
Understood.
Yeah, now let's go. Parliament, they say, is a master of its own rules, yes, but not a master of the Constitution, the enacts. And two, I humbly disagree with lawyer. I believe it's a slip. He said the Parliament can interpret the Constitution, Supreme Court can interpret the Constitution. No, they can state their understanding, but I disagree that they can interpret it. That is how come when a Parliament conducts its acts, somebody goes to the Supreme Court for interpretation. That's the 97, we have the letter and the spirit, all the articles of the Constitution, the letter and the spirit. So when you think you disagree with the ordinary understanding, you go for the interpretation where the purposive interpretation is given. And that is what the leader of the House is doing. People are saying case laws and co. It's true, there were precedents. The speaker cited precedent. I was talking 1997, Kwampepra issue, and J.H. Mensah. The speaker, D.F. Annan, there and then, Kwampepra was in Parliament to give the budget. There and then, he read what he got from Supreme Court, that he's been asked to hold on. So he's sorry the budget cannot be presented because the Supreme Court has stopped or stayed that act. Okay? That's the speaker. And yet the current speaker didn't cite that. Precedents. Okay? And let's go again. The issue that we need to, the LGBTQ issue, my colleagues are citing severally. Yes, public interest is there. Matters that borders on the governance issues is completely different. Because these conducts there can have effect on the governance process.
How?
Okay? Yes. So if it's not, now the speaker says, I've sacked 4 MPs because of something that is meant to happen acts into the future. Because look, we've had 2 instances where people have crossed carpets and they were removed in Parliament. Okay? 2012, Professor Wayo said, crossed from the NDC to the MPP. That in the existing Parliament. Then Kofi Asante, okay, also crossed, and also from the NDC to the MPP, and he was moved out. Okay? Those are the matters of crossing carpets. Because the people, do you know why? The framers of the Constitution envisage that people can be coerced or convinced or brought to move, okay, to this thing. And numbers is important in parliamentary matters. You get it? And so that is what they want to avoid. Once you go there, you think, let's even say you have been bought and you cross for your interest. The law says go back to your people and get the mandate and come back. That is what the framers are talking about. Now, and that's why I keep harping on the issue of let's dissolve parliament, then let's go and do elections and come. That way, if I'm going to go independent or join, it has nothing on parliament.
So are you
Because
suggesting
that current parliament
that
has dissolved.
the parliament should be resolved before the election campaign?
Ordinarily, that's what it should be. Yes, that's the assumption. Because all the acts is for the next parliament. So my conduct now has nothing to do with my,
however, that is not what we have now.
That's not it. You get it? So that's why we need the interpretation. And again, yesterday I had cited that issue here and other platforms. That is it for nothing that a clause in the Constitution is saying 6 months to the next election. There cannot be by-election.
Is it 6 months or 3? I think it's 3 months.
Okay, 3 months to the next election. There cannot be by-election. Is it just for fun? No. And so any interpretation will factor that in. Yesterday, the Chief Justice mentioned that thing. I said, yes, because you cannot read 97 in abeyance. Okay? There are other things that, must come in to hold the movement of those things. The LGBTQ issue is true. The matter is that people have gone to the Supreme Court on matters of human rights. They feel that thing, there are certain inputs there that borders on human rights. And so those things must be interpreted before they proceed. And the president says, okay, if it's human rights and the Supreme Court is working on that. And two, I know that the delay in that matter had to do with the Speaker's deposition delaying. Because the Speaker had to submit his brief or deposition or whatever. He had not done it. He delayed it. Even this one, Thaddeus admitted that he's here to do his filing. Is that not true? Okay? So please, sometimes when we do it, you say, yesterday, so the 5 judges all are just pandering to the whims of the executive. Please. We were in this country. We had a 2013 this thing. Yes, this nation, the mood of the nation is considered. It's true in every decision by the Supreme Court. When 8 months of trial, we use less than 3 minutes to read the judgment. And yet we accepted it in this country. Land cases and co were cited in this thing, reading. So please, these are matters that we need to be careful about. You get it? Mm-hmm. So please, let's all, and I think the mood of the people is considered. Are you saying that when people for constituencies are just being stopped because, no, and that one, it doesn't bother on the mood of the people.
Landed in 10 seconds.
Yes, it doesn't bother on the mood of the people. Mm-hmm. What is good for the goose is equally good for the gander. And we need to look at all these matters. And my last one, interpretation is there in 130. Yes, Article 130, we need to look at that. That is where interpretation is. And last one, the LGBTQ, transmission. Okay, there are remedies in the Constitution. Okay. Once the president refuses to sign, the parliament itself needs a certain quorum to take that decision. It It is there. It's in the Constitution.
All
So
right.
what's the problem?
Just a quick one.
Before.
Let me clarify interpretation. Article 131 of 1992 Constitution. It says the Supreme Court shall have jurisdiction to interpret and enforce the provisions of the Constitution. However, other bodies can interpret. Let me give you the other bodies quickly. The High Court can interpret the Constitution in cases before it, but its decisions can be appealed to the Supreme Court. 2, Court of Appeal can also interpret the Constitution, but its decisions can be appealed to the Supreme Court. Parliament can interpret the Constitution through legislative debates and decisions, but its interpretations are subject to judicial review by the Supreme Court. And the Council of State, an advisory body that can provide guidance on constitutional matters, but its opinions are non-binding. Goes to show you, wait.
Bottom line.
No, Kwejo. It goes to show that these different bodies can interpret the Constitution. However, the Supreme Court is the overall body to interpret the decisions they make in interpreting the Constitution.
All right.
So, Kwejo, when you say that, you disagree with me
So they
that
are not
other bodies...
final.
Right, gentlemen, all too soon.
They are not final,
all too
but they
soon.
have the power
Yeah,
of
all too
interpretation.
soon. We've come to the end of today's session.
And that can be challenged.
We are privileged to have lawyer Kwame Jantua, senior member of the CPP, and George Kwejo Eyisi, Director of Communications, NADMO, a member of the MPP communication team, Timothy Tabwede, Awontirim, the former MP, Bosa North Constituency. Gentlemen, really pleasure joining us this morning. Also, I would like you to know that all those who send their messages, we appreciate that you did so. This show is still on here. My name is Winston Taki. We take a short break, still come back for more on the Prime Morning Show.